Listen, folks, when it comes to knowing the law or the legal process, to be forewarned is to be forearmed, especially when we are talking about elder law. Linda Greer is an attorney with Pfaltzgraff, Beinhauer & Menzies. She is here with Jean Harris, also an attorney, the PBM law firm. They are here with some basic answers for questions that you will need answers to. So good morning, ladies.
Good morning.
Nice to have you
Good
here.
morning. Thanks for having us.
Thank you.
Nobody wants to talk about what happens when a loved one passes away, but the reality is it happens every day. Maybe you can tell us quickly, what is the legal process when a person passes away?
So the court process is something known as probate. So when a person passes away and that individual owned assets in their own individual name, they have to process through the court system, and it's surrogate's court that actually has jurisdiction over this. But what we want to do is get the information out so that people plan ahead so that they can avoid having to go through the court process. So probate can be avoided if you have a joint owner attached to your asset, or you have designated beneficiaries on an asset, or you've taken an opportunity to, prior to your death, transfer ownership of that asset by something maybe like a trust, or taking those steps in advance.
Right. Utilization of a trust is often very important, not just with probate and the concerns for what happens to your assets after you've passed away, but ensuring that they're protected during your lifetime in the event that you need some sort of long-term care, whether that's at home or in a facility.
So when someone says, okay, this person has passed away, we have a single owner of the home, and now it has to go into probate, does that mean, is that actually a period of time where everything gets sorted out?
It is. So in the state of New York, the minimum time period for probate to be open with the court is 7 months. Most estates are open for about 7 months to a year, but there is a process. So you file a petition with the surrogate's court. If the person had a will, that's called the probate petition. If the person died without a will, it's called an administration petition. And if you die without a will, New York State determines by law who inherits your estate. You don't get to decide this, the law decides for you. So more important for you to plan ahead to do these things. But yeah, the court would then appoint the administrator or executor of your estate. That person can now collect your assets, make sure your debts and expenses are paid, and the estate then gets passed along to your heirs. But the process will stay open for at least 7 months.
Jean, some people think, well, I have a will, but today, is that enough?
It really isn't. In fact, in our practice, we advise everyone, and regardless of age, and this isn't something that you should wait to, that you're retiring or you think you might be closer to needing your will, but you need really 3 basic estate planning documents, and these are, at a minimum, a durable general power of attorney, which is the document that allows a person to appoint an agent to handle any legal, business, or financial affairs for them. It's called durable because it continues in the event that they become disabled. So obviously, if you've become disabled, you're not any longer at a point to appoint a person. So you've got that document in place. The next document that you really need to have is a living will healthcare proxy, which is the document where you're appointing a person to make any healthcare or medical decisions for you, and providing them with a list of instruction as what you would like to be done in the event of a catastrophic medical situation. And then really finally, the third piece of the initial estate planning puzzle is the last will and testament.
Let me ask you, Linda, what steps may be taken during one's lifetime to avoid probate?
Sure. So I already mentioned a couple, but adding a joint owner, adding a designated beneficiary on life insurance, IRAs, but one of the most important things is actually taking assets out of your name now and getting those transferred to another individual directly or to a trust. So one of the most common planning techniques that people will use is something called a deed transfer with a retained life estate. So parents will convey ownership of their home to the children while mom and dad retain rent-free life use to the property. Mom and dad get the protection of knowing kids, not that they would do this, but they can't charge you rent, they can't kick you out, they can't sell or mortgage the property without your consent. And we know that when I die, it automatically goes on to my kids. There's also some protection from a nursing home once you clear a 5-year period of time.
Interesting, interesting.
In addition to using something simple and basic like that, we could also talk about using something like a trust, which Jean has mentioned. And that is a way to get those assets out of your individual name into the name of this other legal entity and offer you the ability to avoid probate for all of the assets that are in that trust.
Wow, we're gonna have to stop there because we're out of time, but already we've learned a lot, and if you don't have the answers to those questions, this is the stuff that is going to cost you a lot of money down the road, and maybe your final wishes won't be what you have planned, because you need to really contact this law firm, Pfaltzgraff, Beinhauer & Menzies, the PBM law firm, because they are the folks who really specialize in elder law, okay? They're located at 455 Cayuga Road In Buffalo, here's their number, 204-1055. The PBMlawyers.com. You may want to call today.